Welcome, future sentinels of public health. You stand at the threshold of a career of profound public service. The path to becoming a food safety officer places the well-being of millions directly into your hands. This is a call to action for those with a commitment to integrity and a desire to impact society. You will be an educator, enforcer, and guardian of the nation's food supply. This video class series is designed to be your companion on this rewarding journey. We will delve into the foundations that empower you to perform your duties with confidence. We challenge you to think critically and apply legal principles to real-world scenarios. We have structured our curriculum to instill in you the competence and ethical grounding necessary. This is your opportunity to contribute to a healthier, safer India. Let us begin this journey together with a shared vision of excellence. The Food Safety Officer examination is a highly competitive test. The syllabus is extensive, covering subjects from food science to the Food Safety and Standards Act, 2006. Success demands a structured study plan. The FSO test places a heavy emphasis on the FSS Act, 2006, making it the central pillar of your study. This series is designed to prepare you for this complexity. To gain an edge, your preparation must be superior. This video class series acknowledges this competitive pressure and is structured to provide you with that crucial advantage. The FSO exam is a marathon, not a sprint. With so many study materials online, choosing the right tool can be overwhelming. This video class series is a structured, engaging learning ecosystem designed for the first-time FSO aspirant. We transform dense legal text into a dynamic learning experience with clear explanations and visual aids. Each video module builds a strong foundation, ensuring a progressive learning curve. Our quiz-heavy methodology enhances memory retention. We actively engage you, testing your comprehension with PCS-level multiple-choice questions. We expand, never summarize, exploring each topic in exhaustive detail. This series is your ultimate preparation tool, structured like a personal coaching program. We provide the structure and expertise needed to become a food safety officer. Your guide is Dr. Binesh Desai, known for his TEDx talks and work in safety. His teaching inspires a deep understanding. This course is meticulously designed to build your knowledge effectively. Effective learning is active, with interactive videos, case studies, and quizzes. Dr. Desai simplifies complex concepts, acting as a mentor. His expertise extends beyond academics, enriching the course with real-world perspective. He explains why the law exists and how it's applied. Dr. Desai's commitment ensures you're in capable hands. This video class series is structured into a logical curriculum designed to guide you step by step. Starting with the introduction, we'll understand the exam's demands and align our objectives. Then, we dive into the history of food laws, exploring the reasons for their consolidation. We'll cover the FSS Act structure, key definitions, licensing, and the powers of a food safety officer. Finally, we'll guide you through enforcement, penalties, appeals, and exam strategies to ensure you are fully prepared. The Food Safety and Standards Act, 2006, represents a paradigm shift in India's approach to food regulation and public health. It consolidated 8 different laws into one cohesive statute, creating a single point of reference. One nation, one food law. It established FSSAI as the apex body for setting science-based standards and regulating food manufacture, storage, distribution, sale, and import. The FSS Act introduced a comprehensive farm-to-fork approach, placing responsibilities on food business operators at every stage and shifting the onus of ensuring food safety onto businesses. Your role as an FSO is to verify and enforce this compliance to protect the end consumer from potential harm. Mastering this act is the essential professional requirement for a successful career as a food safety officer. Before the landmark enactment of the Food Safety and Standards Act in 2006, the landscape of food regulation in India was a complex and bewildering maze. It was not governed by a single cohesive legal framework, but by a patchwork of numerous laws, orders, and regulations, many of which were decades old. This multiplicity created a confusing environment for both food businesses and enforcement agencies. Imagine a food manufacturer trying to produce a simple fruit-based product. They would have to navigate the Prevention of Food Adulteration Act, 1954, and simultaneously comply with the Fruit Products Order, 1955. This fragmentation was not just an inconvenience, it was a significant impediment to ensuring uniform food safety. This pre-2006 era lacked a holistic vision for food safety. Each law was created at a different point in time, often in response to a specific problem. For instance, the Milk and Milk Products Order, 1992, focused exclusively on the dairy sector, while the Meat Food Products Order, 1973, dealt with meat and poultry. While each law served a purpose, they operated in silos. There was no single authority to oversee the entire food ecosystem, leading to gaps in regulation and inconsistencies in enforcement. A food business operating in multiple states could face different interpretations and enforcement standards, making compliance difficult and costly. The lack of a unified structure meant there was no single point of contact. If a consumer had a complaint, determining the correct authority was a challenge. For a food business operator seeking guidance, the process was cumbersome, involving multiple ministries and departments. The Ministry of Health and Family Welfare handled the Prevention of Food Adulteration Act, while the Ministry of Food Processing Industries managed the Fruit Products Order. This division of responsibility created bureaucratic hurdles, slowed down processes, and fostered diffused accountability. This fragmented approach was not sustainable for a rapidly growing economy. This maze of multiple laws created confusion rather than clarity, fragmentation rather than integration. It hindered the development of a modern, science-based food safety regime and made it difficult for Indian products to meet international standards. The system was reactive, focused on prosecuting offenders after incidents rather than preventing them. India needed to move beyond this piecemeal approach. A fundamental overhaul was required to consolidate these laws into a single, comprehensive statute. This pressing need set the stage for the FSS Act, 2006. The Prevention of Food Adulteration Act, 1954, or PFA Act, was the principal legislation governing food safety in India for over 5 decades. Its objective was to prevent food adulteration by defining adulteration and prescribing punishments. However, its punitive nature created mistrust between regulators and the food industry. The Act's limited scope and rigid framework struggled with modern complexities and international standards. This drove the need for a new preventive, science-based and facilitative law, the FSS Act. Beyond the PFA Act, the regulatory environment was further complicated by a series of sector-specific orders issued under the Essential Commodities Act, 1955. These included prominent regulations like the Fruit Products Order, 1955, the Meat Food Products Order, 1973, and the Milk and Milk Products Order, 1992, among others. Each of these orders was designed to regulate a specific category of food products, setting standards for quality, processing, and packaging. For example, the FPO was mandatory for any manufacturer of fruit jams, jellies, squashes, or pickles. Similarly, the MFPO laid down sanitary and hygienic standards for slaughterhouses and meat processing plants. These orders were crucial for maintaining quality in their respective sectors. The fundamental problem, however, was that these orders operated independently of each other and of the overarching PFA Act. This created a system of multiple licenses and overlapping jurisdictions that was both inefficient and confusing. A food business that produced a range of products might need to obtain a license under the PFA Act from the local health authority, an FPO license from the Ministry of Food Processing Industries, and perhaps an MMPO registration if they also handled dairy. This meant dealing with multiple government agencies, each with its own set of inspectors, procedures, and paperwork. This fragmentation placed a heavy compliance burden on businesses, especially small and medium-sized enterprises, stifling growth and innovation. This fractured system inevitably led to inconsistencies in standards and enforcement. The standards laid down in one order might not align perfectly with the standards under the PFA Act or another order. Enforcement was carried out by different agencies with varying levels of training, resources, and priorities. An inspector from the Ministry of Food Processing Industries enforcing the FPO might have a different approach than a municipal food inspector enforcing the PFA Act. This lack of uniformity created an uneven playing field for businesses and made it impossible to implement a consistent nationwide food safety policy. The farm-to-fork concept was simply unattainable when the regulatory framework itself was broken into so many disconnected pieces. The challenge of these fragmented orders highlighted the urgent need for consolidation. It was clear that a single unified law was needed to bring all these different regulations under one umbrella. The goal was to create a single regulatory body that could oversee all sectors of the food industry, harmonize standards, and streamline the licensing process. This would not only reduce the burden on food businesses, but also lead to more effective and consistent enforcement. The idea of repealing these multiple orders and subsuming their provisions into a new, comprehensive Food Safety and Standards Act was a central and honestly revolutionary aspect of the proposed legal reform. promising to end the era of regulatory fragmentation. By the late 1990s and early 2000s, the pressure to reform India's outdated food laws was mounting from multiple directions. Domestically, the country was undergoing significant economic and social transformation. Rising incomes, increasing urbanization, and changing lifestyles led to a dramatic shift in consumer food habits. There was a growing demand for processed, packaged, and ready-to-eat foods, as well as a greater variety of products from across the country and the world. Consumers were also becoming more aware and vocal about food safety and quality issues, partly due to increased media coverage of foodborne illness outbreaks and adulteration scandals. The old laws were simply not equipped to regulate this new, dynamic, and complex food market effectively. Simultaneously, the Indian food industry itself was evolving. It was growing in scale and sophistication, with larger players entering the market and supply chains becoming longer and more intricate. These businesses needed a clear, predictable, and modern regulatory environment to thrive. The existing system of multiple laws and licenses was a major bottleneck, creating delays, increasing costs, and hindering their ability to compete. The industry began to advocate for a simplified, unified legal framework that would facilitate ease of doing business while ensuring high standards of safety. They recognized that a modern food law would not be a burden, but a necessary enabler for growth, innovation, and building consumer trust. On the global front, the pressures were just as significant. The world was moving towards a harmonized approach to food safety, guided by international bodies like the World Health Organization, the Food and Agriculture Organization, and the Codex Alimentarius Commission. The agreement on the application of sanitary and phytosanitary measures under the World Trade Organization required member countries to base their food safety measures on scientific principles and international standards. India's fragmented and outdated legal framework was a major trade barrier, making it difficult for Indian food exporters to meet the stringent requirements of developed countries and hindering access to lucrative international markets. A new law aligned with global standards was essential for boosting India's food exports. These converging pressures, from aware consumers, a modernizing industry, and the demands of global trade, created an undeniable momentum for change. It was no longer a question of if India's food laws needed reform, but how and when. The consensus was that incremental changes would not be enough. A complete legislative overhaul was necessary. A new law had to be envisioned that was comprehensive, integrated, science-based, and aligned with international best practices. It needed to protect consumers, facilitate trade, and promote a culture of self-regulation and responsibility within the food industry. This powerful combination of domestic and global drivers paved the way for the conceptualization and eventual enactment of the Food Safety and Standards Act, 2006. The creation of the new food law required a fundamental shift in regulatory philosophy. The most significant change was the move to a primarily preventive and proactive system. This philosophy is embedded in the FSS Act, emphasizing the food business operator's responsibility to implement safety systems. Another cornerstone was the adoption of science-based standards. The vision was to establish an independent scientific authority responsible for setting food standards based on rigorous risk assessment. The concept of an integrated farm-to-fork approach was central to the new law's design. The new law was conceptualized to cover all stages of the food chain. The idea was to create a unified information and regulatory system accessible to all stakeholders. This involved establishing the Food Safety and Standards Authority of India. By consolidating functions, the new law aimed to bring clarity and efficiency to India's food safety regime. The journey from concept to reality was a meticulous and consultative legislative process. Recognizing the profound need for reform, the Government of India initiated a comprehensive review of the existing food laws. This process involved extensive consultations with a wide range of stakeholders, including consumer organizations, food industry associations, scientists, technologists, and legal experts. The goal was to build a consensus and ensure that the new legislation would be practical, effective, and widely accepted. A group of ministers was constituted to examine the issue in depth and provide recommendations for a new integrated food law. This inclusive approach was crucial in shaping a balanced and robust piece of legislation. Based on the recommendations and widespread consultations, the Food Safety and Standards Bill was drafted. The bill was a revolutionary document that proposed the repeal of 8 existing laws, including the Venerable PFA Act of 1954 and various sector-specific orders. In their place, it proposed a single, comprehensive statute that would govern the entire food sector. The bill's primary objective was clearly stated: to consolidate the laws relating to food and to establish the Food Safety and Standards Authority of India. This new authority would be responsible for laying down science-based standards and regulating the entire food supply chain to ensure the availability of safe and wholesome food for human consumption. It was a bold and ambitious proposal. The bill was introduced in the Indian Parliament, where it underwent further scrutiny and debate. Legislators from across the political spectrum recognized the critical importance of modernizing the country's food safety regime. They discussed its various provisions, from the composition and functions of the FSSAI to the new system of licensing and registration, the powers of enforcement officers, and the structure of penalties. The legislative debate highlighted the shared commitment to strengthening consumer protection and facilitating trade. After thorough deliberation in both houses of Parliament, the bill received the assent of the President of India on the 23rd of August, 2006, and it officially became the Food Safety and Standards Act, 2006. The enactment of the FSS Act, 2006, was a historic and transformative moment for food regulation in India. It marked the culmination of years of effort to move away from a fragmented and outdated legal framework. The Act represented a complete paradigm shift, introducing modern regulatory concepts and aligning India's food safety system with international standards. Although the Act was passed in 2006, its provisions were operationalized in a phased manner over the next few years, culminating in the establishment of the FSSAI and the notification of its associated rules and regulations in 2011. This legislative milestone laid a new, solid foundation for ensuring food safety for over 1 billion people. The vision of one nation, one food law, signifies the end of confusing laws and the dawn of a unified regulatory system. The primary goal was to bring all matters of food safety and standards under a single legislative umbrella. Achieving this vision involved repealing previous food laws and establishing the Food Safety and Standards Authority of India as the single national authority. A food business operator needs only one license or registration. Ultimately, the One Nation, One Food Law principle is about strengthening consumer protection. It ensures that every citizen has the right to safe and wholesome food. The Food Safety and Standards Act, 2006, is structured into 12 distinct chapters and 101 sections. Each chapter deals with a specific aspect of the food safety ecosystem. Chapters 1 to 4 lay the groundwork, introducing key terms and establishing the FSSAI. Chapters 5 to 8 form the operational and enforcement core. Chapters 9 to 12 deal with legal and administrative support, including penalties and appeals. Together, these chapters create a complete legal framework for food safety in India. The Food Safety and Standards Act, 2006, begins with Chapter 1, Preliminary, covering Sections 1 to 3. Section 3 defines key terms like food, adulterant, and unsafe food, crucial for interpreting the Act. Chapter 2, Sections 4 to 17 establishes the Food Safety and Standards Authority of India, FSSAI. This details its composition, a chairperson and 22 members, with 1/3 women. Chapter 2 transforms FSSAI into a functioning institution headquartered in Delhi, defining its structure and committees. Chapter 3 of the FSS Act, Section 18, outlines the general principles of food safety. This chapter acts as the philosophical compass for the entire legislation, guiding all subsequent rules and enforcement actions. It mandates a risk-based approach and emphasizes transparency and public consultation. Chapter 3 enshrines the precautionary principle, allowing authorities to take preventive measures. Regarding potential public health risks, this chapter mandates that the entire food supply chain must be considered, fully cementing the farm-to-fork ideology. These guiding principles are legally binding directives that shape the application of the entire food safety law. Chapter 4, titled General Provisions as to Articles of Food, gets into the specifics of what can and cannot be in our food. Significantly, this chapter also includes provisions for genetically modified foods, organic foods, and functional foods. Section 22 specifically deals with packaging and labeling of foods, prohibiting misleading labels. Chapter 5 of the FSS Act covers the import of food articles. Section 25 states that no person shall import unsafe or misbranded food without a license. Section 26 outlines the responsibilities of the food business operator. Section 28 introduces food recall procedures. Chapter 6 is operationally significant for food business operators and food safety officers. Section 31 mandates licensing and registration of food businesses. Section 29 provides for the appointment of a Commissioner of Food Safety for each state. Section 30 details the appointment of the designated officer for each district. Chapter 7 of the FSS Act, Sections 36 to 42, is the heart of the enforcement machinery. This empowers you, the future food safety officer. Section 38 details the powers of food safety officers, including the authority to take samples, seize food, and inspect premises. Section 40 allows consumers to have food analyzed. Chapter 8 covers sections 43 to 47 and is dedicated to the analysis of food. Section 47 details the sampling and analysis procedure. Adherence to this procedure is mandatory. Chapter 9 of the FSS Act details the consequences of violating the law, defining offenses and penalties. It creates a nuanced system of offenses, ranging from fines to imprisonment, with graded penalties based on the harm caused by unsafe food. Chapter 10 establishes adjudication and the Food Safety Appellate Tribunal. An adjudicating officer holds inquiries and imposes penalties. Appeals go to the Food Safety Appellate Tribunal, with a further appeal to the High Court. This system ensures fair and transparent justice. Chapter 11 of the Food Safety and Standards Act, which covers sections 77 to 80, deals with the crucial financial and administrative aspects that help the FSSAI function effectively. This chapter, called Finance, Accounts, Audit and Reports, really forms the financial backbone for the authority. Section 77 spells out the sources of funding for the FSSAI, which include grants from the central government, fees collected under the Act, like licensing fees, and any other contributions received. This ensures the authority has the necessary financial resources to carry out its wide-ranging mandate, from setting standards and conducting research to running surveillance and awareness programs. A well-funded regulator, honestly, is an effective regulator. To maintain financial discipline and transparency, this chapter sets out strict requirements for accounting and auditing. Section 78 makes it mandatory for the FSSAI to maintain proper accounts and prepare an annual statement of accounts in a form prescribed by the central government, in consultation with the Comptroller and Auditor General of India, or CAGI. Then Section 79 says these accounts have to be audited every year by the CAGI. This external audit by the highest auditing body in the country ensures that the authority's finances are managed with integrity and accountability, which is absolutely essential for maintaining public trust in such a key institution. On top of that, Chapter 11 highlights the importance of reporting and public accountability. Section 80 requires the FSSAI to prepare an annual report detailing its activities during the previous year. This report, along with the audit report, must be placed before both houses of Parliament. This provision makes sure that the FSSAI's performance is subject to parliamentary oversight and public scrutiny. It holds the authority answerable for its actions and achievements, promoting a culture of transparency and continuous improvement. These financial and reporting mechanisms are, honestly, the silent but essential pillars that support the entire structure of the Act. Finally, Chapter 12, Sections 81 to 101, called the Miscellaneous Chapter, acts as a catch-all for various important provisions that don't fit neatly into the other chapters. This chapter gives the central government and the FSSAI the power to make rules and regulations to carry out the provisions of the Act. It includes a really vital protection clause in Section 86, which protects officers acting in good faith under the Act from legal prosecution. It also contains Section 97, the crucial repeal and savings clause, which formally repeals the 8 old food laws while making sure that actions taken under those old laws remain valid. This chapter, in essence, provides the necessary flexibility and legal safeguards to ensure the smooth and effective implementation of the entire Act. The Food Safety and Standards Authority of India, or FSSAI, established under Chapter 2 of the Act, is the supreme authority and the single point of reference for all matters related to food safety and standards in the country. Its main mandate, as mentioned in the preamble of the Act, is to lay down science-based standards for articles of food and to regulate their manufacture, storage, distribution, sale, and import, all to ensure the availability of safe and wholesome food for human consumption. But the FSSAI is not just a rule-making body, it's actually a multifaceted organization with a really wide range of functions that touch every part of the food ecosystem. It acts as a regulator, facilitator, and enabler of food safety. One of the most important functions of the FSSAI is framing regulations and standards. This is its core scientific duty. The authority develops and notifies standards and guidelines for food products, covering things like maximum limits for additives, contaminants, pesticide residues, and microbiological counts. It also sets regulations for food packaging, labeling, and advertising, making sure consumers get accurate information. These standards are not at all arbitrary. They're developed through a rigorous, science-based process involving expert scientific panels and the scientific committee, and they're aligned with international benchmarks like Codex Alimentarius. This not only facilitates international trade, but also ensures global best practices are followed. Beyond setting standards, the FSSAI plays a key role in the licensing and registration of food business operators. While the actual issuance of state licenses and registrations is handled by state authorities, FSSAI formulates the overall procedures and conditions for these processes. It directly handles licensing for large FBOs that operate in multiple states, as well as all food importers. This central licensing function ensures uniformity and high standards for the major players in the food industry. The FSSAI also sets up mechanisms for accrediting laboratories for food testing and certification bodies for food safety management systems, building a solid infrastructure for compliance verification. Its role extends to surveillance monitoring and information dissemination. The authority collects and analyzes data to identify emerging food safety risks and conducts nationwide surveillance to assess compliance with its standards. A really important function is providing scientific advice and technical support to both the central and state governments in policymaking. Plus, the FSSAI is responsible for promoting general awareness about food safety and standards among the public. Through different initiatives and campaigns, it educates consumers and FBOs, encouraging a culture of food safety. It also provides training and capacity building for regulatory staff, making sure enforcement is both effective and consistent across the country. Before diving into the Food Safety and Standards Act 2006, let's master its language. Section 3, defining key terms, is critical for any aspiring food safety officer. These precise legal constructs form the foundation of every rule and enforcement action. A deep understanding of these definitions is necessary for effective enforcement. Identifying unsafe food or a food business operator carries specific legal consequences. This precision allows uniform application of the law nationwide. We'll break down each key definition, exploring its components for your daily work. Mastering these terms is crucial, especially for competitive exams. Every term is a building block, empowering you to interpret the law correctly. Let's begin with the fundamental definition of food under this law. The Food Safety and Standards Act hinges on its definition of food, found in Section 3. The Act defines food as any substance, processed or unprocessed, intended for human consumption. This includes raw produce, processed items, genetically modified food, infant food, packaged water, alcoholic drinks, and chewing gum. Food excludes animal feed, live animals unless processed, plants pre-harvest, drugs, cosmetics, and narcotic substances. The definition includes any substance used during manufacture, such as additives, processing aids, preservatives, and coloring agents. This ensures safety at every step, embodying the farm-to-fork principle. The Act defines the activities and people it regulates, including the entire food supply chain. A food business is any undertaking, public or private, involved in any stage of the food life cycle. The food business operator, FBO, is responsible for compliance. This places legal responsibility on a specific individual or entity. Food safety is the assurance that food is acceptable for human consumption according to its intended use. These definitions create the regulatory ecosystem, governing food businesses and holding FBOs accountable. This ensures food safety for the consumer. Food safety officers must distinguish between contaminants, hazards, and adulterants, each with specific legal definitions under the FSS Act. Contaminants are unintended substances in food, like pesticide residues or heavy metals, introduced during production or from the environment. Hazards are broader, any biological, chemical, or physical agent or condition that could harm health, such as bacteria, toxins, or glass shards. Adulterants, in contrast, are materials intentionally added to degrade food quality, often for economic gain, like watering down milk or adding non-permitted colors. Correctly classifying these is crucial. The legal consequences and penalties differ based on whether a substance is a contaminant, hazard, or adulterant. For example, possessing an adulterant with intent is a specific offense. Mastering these distinctions enables FSOs to enforce the law effectively and build strong cases against violators. Not all violations are immediately dangerous. Some involve quality or misleading information. Substandard food fails to meet FSSAI's quality standards but isn't unsafe. For example, juice with less fruit pulp than required. Selling substandard food is a violation. but penalties are less severe than for unsafe food. Misbranded food involves false or deceptive labeling, like selling regular rice as basmati or making unsubstantiated health claims. Even safe, high-quality food is misbranded if the label is non-compliant. FSOs must inspect both food and labels, as accurate labeling protects consumer rights. Both violations carry penalties, emphasizing the importance of quality and transparency. Unsafe food is the most serious violation under the FSS Act, defined as any food that could harm health. This includes food with harmful contaminants, adulterants, poisonous substances, or that is spoiled, decomposed, or unhygienically processed. FSOs must act immediately when unsafe food is found, seizing and destroying products as needed. Even food stored or prepared in filthy conditions can be declared unsafe, empowering FSOs to prevent harm before lab results. Using prohibited substances or exceeding legal limits for additives also renders food unsafe. Penalties escalate with the severity of harm, up to imprisonment. Understanding this definition is vital for FSOs handling high-stakes enforcement. The FSS Act relies on a hierarchy: designated officer, DO, food safety officer, FSO, and food analyst. The DO oversees district food safety, issues licenses, and sanctions prosecutions. The FSO is the field enforcer, inspecting businesses, collecting samples, and investigating complaints. The food analyst, a scientific expert, tests samples and provides reports that form the backbone of legal cases. This trio works in tandem. FSO gathers evidence, analyst validates it, DO decides on action. Effective coordination among them ensures robust enforcement. Understanding these roles is essential for every FSO. No food business can operate legally without a license or registration under Section 31 of the FSS Act. This requirement brings all food businesses, big or small, under regulatory oversight. Licensing creates a comprehensive database, enabling targeted inspections and effective enforcement. The application process educates FBOs on hygiene and safety, ensuring basic standards are met before operations begin. Displaying a valid license builds consumer trust and signals accountability. For FSOs, the registry is a vital tool for monitoring and enforcement. Licensing and registration form the foundation of India's food safety system. Section 2. Who needs what? Differentiating between registration, state, and central licenses. The FSS Act recognizes that a one-size-fits-all approach to licensing would be impractical for India's diverse food sector. The FSS regulations establish a three-tiered system: registration, state license, and central license. Registration is intended for petty food business operators with a low turnover. State licenses are required for mid-sized food businesses within a single state. Central licenses are reserved for large-scale food businesses with national or international scope. The FSSAI's Food Safety Compliance System, FSSAI, streamlines food license and registration, replacing the older FLRS. It serves as a single access point for food businesses. Businesses determine eligibility via an online tool, which directs them to the correct application form. FBOs then complete the form, upload documents, and pay fees online. Applications can be tracked in real time. FSOs may conduct inspections, submitting reports via FSSAI. Authorities then grant, request more info, or reject the application. This digital process enhances efficiency and transparency. Obtaining a food license is an ongoing commitment. Displaying the certificate is a fundamental duty. Regulations mandate that every FBO must prominently display the license at their place of business, so consumers can easily see it. The FSSAI license number must be displayed on receipts and invoices. For prepackaged food, the FSSAI logo and license number must be on the label for traceability. Licenses are valid for 1 to 5 years, requiring timely renewal. Apply for renewal at least 30 days before expiry to avoid late fees. An expired license requires ceasing business activities and can lead to penalties. Section 26 of the FSS Act outlines the responsibilities of the food business operator, FBO. It states that every FBO shall ensure food safety at all stages of their business. This shifts the burden of ensuring safety from the government inspector to the business owner. FBOs must exercise due diligence to ensure the safety and quality of their raw materials and processes. FBOs are prohibited from manufacturing, storing, or selling unsafe food. Section 26 also prohibits employing anyone with an infectious disease in food handling. This section serves as the legal basis for detailed sanitary and hygienic requirements. Section 26 makes the FBO the primary guarantor of food safety. The FSS Act provides a framework based on best practices to help food business operators with food safety. This framework is the implementation of good manufacturing practices, or GMP, and good hygienic practices, or GHP. GMP and GHP are mandatory requirements for all licensed FBOs. The Act encourages businesses to implement a comprehensive food safety management system, or FSMS. A well-designed FSMS integrates GHP, GMP, and often includes the principles of hazard analysis and critical control points, or HACCP. The role of the FSO is to evaluate the robustness of the FBO's entire FSMS. A strong FSMS is a clear indicator that an FBO is serious about its commitment to producing safe food consistently. In today's global food supply chain, traceability is key. As mandated by regulations, traceability is tracking food through all stages of production and distribution. Food business operators must maintain a system to identify their suppliers and who they supply to, keeping records for inspection. Traceability is critical during a food safety crisis, enabling quick identification and targeted recalls, protecting public health. Even with the best systems, things can go wrong. A batch may become contaminated, or a new hazard discovered. Food recalls quickly remove unsafe food from the market, protecting public health. Section 28 of the FSS Act places responsibility on food business operators to initiate a recall if food is unsafe. FSS regulations provide a framework for recalls. FBOs must have a written recall plan as part of their FSMS. When initiating a recall, authorities must be informed and a clear recall notice issued to customers, with instructions on product handling. Food safety officers oversee the recall, ensuring it's effective. A well-executed recall is critical for managing food safety emergencies and demonstrates a commitment to consumer safety. The Food Safety Officer, or FSO, is a frontline warrior of public health. The Commissioner of Food Safety appoints FSOs for specific local areas. This role confers specific powers and immense responsibilities. Your duties include regular inspections to verify compliance, procuring samples for analysis, and investigating consumer complaints. The FSO role requires scientific knowledge, legal acumen, and unwavering integrity. Section 38 of the FSS Act equips you with powers to enforce the Act. A key power is taking samples of any food article or substance from manufacturing, storage, or sales locations. You can enter and inspect premises at reasonable times, including factories, restaurants, and vehicles. The Act grants you powers of a police officer for search and inspection. Another significant power is seizure of food violating the Act. For perishable foods deemed unsafe, you can issue a written notice to the FBO and destroy it, eliminating immediate public health risks. Section 47 details the method for taking a sample. This section, sampling and analysis, is procedurally critical for a food safety officer. Adherence is mandatory. Any deviation can compromise the sample's legal validity. The process begins with a written notice to the FBO, informing them of their rights. Then, divide the sample into 4 marked and sealed parts. 1 part goes to the food analyst, 2 to the designated officer, and 1 to the FBO. This system ensures fairness and allows for independent testing. Dispatch the sample and prepare a detailed witnessed record. Mastering this procedure is crucial for a successful FSO career. Not every instance of non-compliance warrants the immediate drastic action of prosecution or license cancellation. The FSS Act provides for a graded response system that allows for corrective action and gives the food business operator an opportunity to improve. The primary tool for this is the improvement notice, as detailed in Section 32 of the Act. If a designated officer, often based on a report from an FSO, has reasonable grounds for believing that an FBO has failed to comply with any regulations, they can issue an improvement notice. This is a formal, written communication that serves as a legal warning, clearly stating the specific provisions that have been violated and the reasons for the officer's belief. The improvement notice is not just a vague instruction to do better. It must be specific and actionable. The notice will detail the exact measures that the FBO needs to take to rectify the non-compliance. This could range from repairing a leaky roof or installing a pest control system to implementing proper record keeping for traceability or sending staff for hygiene training. Crucially, the notice will also specify a reasonable time period within which these corrective actions must be completed. This period must be realistic, giving the FBO a fair chance to make the necessary changes. This mechanism embodies the Act's facilitative and preventive philosophy, aiming to bring businesses into compliance rather than simply punishing them for their first offense. If a food business operator fails to comply with an improvement notice within the specified time, the consequences become more severe. The designated officer is then empowered to take further action, which can include suspending the FBO's license. The license remains suspended until the officer is satisfied that the FBO has taken the required corrective measures. This escalation from a notice to a suspension creates a powerful incentive for the FBO to take the improvement notice seriously. For an FSO, recommending the issuance of an improvement notice is a key part of your toolkit for driving positive change and ensuring sustained compliance among the businesses in your area. In situations where there is an immediate and grave risk to public health, the Act provides for a more powerful tool, the prohibition order. If an FBO is convicted of an offense under the Act, the court can, in addition to any other penalty, impose a prohibition order. This order can prohibit the FBO from continuing to operate the business, prevent them from using certain premises or equipment, or even ban the individual from being involved in any food business for a specified period. This is a drastic measure reserved for serious or repeated violations that demonstrate a flagrant disregard for food safety, ensuring that operators who pose a persistent threat to public health are removed from the system entirely. The FSS Act creates a mechanism, separate from criminal courts, called adjudication. Section 68 provides for the state government to appoint an adjudicating officer, or AO, to provide a speedy forum for monetary penalty cases, reducing the burden on the justice system. The AO holds inquiries and imposes penalties for contraventions, detailed in sections 50 through 67, including selling substandard or misbranded food. The AO issues a notice to the food business operator, offering a hearing. The AO's proceedings are quasi-judicial, following natural justice principles for a flexible inquiry. The AO's decision is binding and penalties must be paid. Section 6 details the penalties for quality and labeling violations. The FSS Act establishes a graded system of penalties proportionate to the offense. For quality, composition, or truthful communication violations that don't make food unsafe, the Act prescribes monetary penalties. The Act also addresses misleading consumers through improper labeling or branding. Penalties aren't arbitrary. Section 49 lays down principles for determining the penalty amount, ensuring fairness in each case. Knowing these sections is crucial for food safety officers to classify offenses and understand legal consequences. When a food safety violation crosses the line from just a quality issue to a direct threat to human health, the FSS Act actually imposes its most severe penalties. Section 59, which is titled Punishment for Unsafe Food, is the ultimate deterrent in the legislation, moving beyond just monetary fines to include imprisonment. This section establishes a graded system of punishment that directly correlates with the degree of harm caused. This provision really underscores the Act's primary commitment to protecting human life and health, making it clear that any food business operator whose negligence or actions lead to illness or death will face the full force of the law in a criminal court. The penalties under Section 59 are structured in a clear, escalating hierarchy. In the first instance, where the consumption of unsafe food does not result in any injury, the food business operator can still be punished with imprisonment for a term which may extend to 6 months and a fine which may extend to 1 lakh rupees. This holds the food business operator accountable, even if no one was actually harmed. If the consumption of the unsafe food results in a non-grievous injury, the punishment increases significantly to imprisonment for a term which may extend to 1 year, and a fine which may extend to 3 lakh rupees. The consequences become even more dire if the harm is serious. Where the consumption of unsafe food leads to a grievous injury, the punishment is imprisonment for a term which may extend to 6 years, and a fine which may extend to 5 lakh rupees. The Act reserves its most stringent punishment for the worst possible outcome. If the consumption of unsafe food results in the death of a person, the food business operator shall be punished with imprisonment for a term which shall not be less than 7 years, but which may extend to imprisonment for life, and a fine which shall not be less than 10 lakh rupees. This section also includes provisions for compensation. Under Section 65, the court can direct the guilty food business operator to pay compensation to the victim. The amount of compensation can be up to 5 lakh rupees in case of grievous injury, and not less than 3 lakh rupees in case of death. These provisions represent the Act's most powerful tools for ensuring justice for victims and creating an uncompromising deterrent. For a food safety officer, any case involving potentially unsafe food must be handled with the utmost seriousness. In the modern food industry, a vast number of food businesses are not run by individuals, but by companies, firms, or other associations of individuals. The FSS Act recognizes this reality and includes a specific provision, Section 66, to address how offenses committed by these corporate entities should be handled. This section is crucial for ensuring that accountability is not diffused within a complex corporate structure and that the real decision-makers can be held responsible. It establishes the principle of vicarious liability, meaning that the people in charge of the company's affairs can be held liable for the offenses committed by the company itself, preventing them from hiding behind the corporate veil. Section 66, subsection 1, states that if a company commits an offense under the Act, every person who, at the time the offense was committed, was in charge of, and was responsible to, the company for the conduct of its business, shall be deemed to be guilty of the offense. This means that individuals like the managing director, the CEO, or a designated factory manager can be prosecuted alongside the company. This provision ensures that there is always a directing mind who can be held accountable, preventing a situation where a company is fined but no individual faces the consequences, especially in cases where imprisonment is a potential penalty. However, the Act provides a defense for such individuals. A person can escape liability if they can prove that the offense was committed without their knowledge or that they had exercised all due diligence to prevent the commission of such an offense. This due diligence defense is important. It means that a director who has implemented a robust food safety management system, conducted regular audits, and taken all reasonable steps to ensure compliance might be able to show that they are not personally culpable. This encourages senior management to be proactive and genuinely invested in the company's food safety culture, rather than being mere figureheads. The section further clarifies that even if a person in charge is not the primary responsible individual, other directors, managers, secretaries, or officers of the company can also be held liable if it is proved that the offense was committed with their consent or connivance, or is attributable to any neglect on their part. This widens the net of accountability to include any senior official whose actions or negligence contributed to the violation. For a food safety officer and the legal team, this means that during an investigation into an offense by a company, it is essential to identify not just the offense itself, but also the individuals within the corporate hierarchy who are responsible for or complicit in the act, ensuring that justice is both comprehensive and personal. The Food Safety and Standards Act includes an appellate mechanism. This system provides a check on enforcement authorities, ensuring food business operators have their cases re-examined by an independent body. The primary forum is the Food Safety Appellate Tribunal, or FSAT, a specialized expert forum. Understanding the appeals process is crucial for you as a future food safety officer. The possibility of an appeal means your work must be impeccable. This module will guide you through the appellate journey. The right to appeal must be exercised according to the Act's rules and timelines. According to the FSS Act, any person aggrieved by an adjudicating officer's order may appeal to the Food Safety Appellate Tribunal. Appeals must be filed within 45 days of receiving the order. The appeal must be submitted in a specific form with the required fees. The appellant can appear in person or through an authorized legal representative. This process provides a structured path to justice. The Food Safety Appellate Tribunal, or FSAT, is the specialized judicial body established to be the first court of appeal for matters arising from the orders of adjudicating officers. Section 70 of the FSS Act empowers either the central government or the state governments to establish one or more such tribunals by notification. The purpose of creating a dedicated tribunal is to ensure that appeals are heard by a forum that can develop expertise in the specific nuances of food safety law, leading to more consistent and well-reasoned judgments. The jurisdiction of each FSAT is also specified in the notification, ensuring clarity on which tribunal should hear appeals from which geographical areas or districts, preventing confusion and administrative hurdles for appellants. The composition of the FSAT is designed to ensure judicial competence and independence. Each tribunal consists of a single member, who is referred to as the presiding officer. The Act lays down a strict and high qualification for this position to guarantee that the person hearing the appeal has a strong judicial background. According to Section 73, the presiding officer of the FSAT must be a person who is, or has been, a district judge. This requirement is critical. A district judge is a senior and experienced member of the judiciary, well-versed in evaluating evidence, interpreting statutes, and conducting judicial proceedings. This ensures that the FSAT functions with the same level of judicial rigor and authority as a conventional district court. The appointment of the presiding officer is made by the central government or the state government, as the case may be. but it is done in consultation with the Chief Justice of the High Court. This consultation with the head of the state's judiciary is a vital safeguard that protects the independence of the tribunal. It ensures that the appointment is based on merit and judicial experience, rather than on purely executive considerations. This process reinforces the FSSAI's status as an impartial judicial body, giving all parties confidence that their case will be heard fairly and without bias. The presiding officer holds office for a specified term, further securing their independence from executive influence during their tenure. For an FSO aspirant, understanding this structure is important because it highlights the seriousness with which the Act treats the appellate process. The cases that you initiate on the ground, if they result in an adjudication and a subsequent appeal, will ultimately be reviewed by a senior judicial officer of the rank of a district judge. This underscores the need for absolute professionalism and adherence to legal procedures in your work. The robust and independent structure of the FSAT serves as a constant reminder that your enforcement actions are subject to the highest levels of judicial scrutiny, motivating you to perform your duties with the utmost diligence and integrity. The Food Safety Appellate Tribunal is vested with significant powers to ensure it can effectively dispense justice. A key feature of its functioning, as outlined in Section 71, is that it is not bound by the rigid procedures laid down in the Code of Civil Procedure, 1908. Instead, the tribunal is to be guided by the principles of natural justice. This is a profound and important distinction. It means that the FSAT's primary focus is on fairness, equity, and ensuring that both parties get a reasonable opportunity to be heard, rather than on strict adherence to technical procedural rules. This flexibility allows the tribunal to conduct its proceedings more efficiently and to focus on the substantive merits of the case before it. Despite this procedural flexibility, the tribunal is armed with the same powers as a civil court for certain critical functions. This ensures it has the necessary authority to conduct a thorough and proper inquiry. These powers include summoning and enforcing the attendance of any person and examining them on oath, requiring the discovery and production of documents, receiving evidence on affidavits, issuing commissions for the examination of witnesses or documents, and reviewing its own decisions. Essentially, the FSAT has all the necessary tools to compel the production of evidence and testimony, ensuring that it can get to the bottom of the matter and make a decision based on a complete factual record. Every proceeding before the Food Safety Appellate Tribunal is deemed to be a judicial proceeding within the meaning of the Indian Penal Code. This legal status is significant, as it means that giving false evidence or fabricating evidence before the tribunal is a criminal offense, punishable under the law. This provision ensures the sanctity and seriousness of the proceedings, compelling all parties and witnesses to be truthful. Furthermore, the tribunal is deemed to be a civil court for the purposes of the Code of Criminal Procedure, which gives it the power to handle issues like contempt of its authority, ensuring that its orders and proceedings are respected by all. After hearing the appeal, the tribunal has the power to pass any order it deems fit. This can include confirming the original order of the adjudicating officer, modifying it, or setting it aside completely. If the tribunal sets aside the penalty, the FBO is absolved of the liability. If it modifies the order, it might reduce the penalty amount if it finds it to be excessive. The order of the tribunal is final, meaning it is legally binding on both parties. This finality brings a conclusion to the dispute at this level, providing certainty to the FBO and the Food Safety Administration, subject only to one further, limited right of appeal to the High Court. The FSS Act allows a final appeal to the High Court for those aggrieved by the tribunal's decision. Section 72 of the Act grants the right to appeal. An appeal must be filed within 60 days from the date of communication. The appeal can be filed on any question of fact or law arising out of the tribunal's order. The High Court conducts a comprehensive review. The decision of the High Court is the final word. There is no further statutory right of appeal, though a special leave to appeal to the Supreme Court is theoretically possible. The judgment of the High Court brings finality to the legal dispute. A multi-tiered appellate system, including the Food Safety Appellate Tribunal and the High Court, ensures fairness in the FSS Act's enforcement. It protects food business operators from arbitrary decisions and promotes accountability among adjudicating officers. This structure develops consistent legal interpretations, guiding future decisions and clarifying the law. The system reinforces a science-based approach, subjecting evidence to judicial scrutiny. Ultimately, it balances public health with individual justice, ensuring fair and accountable enforcement. As we conclude this video class series, let's synthesize the knowledge we've gained about the Food Safety and Standards Act 2006. Our journey began with understanding the shift from fragmented laws to a unified science-based system. We explored the FSSAI's functions, mastered legal definitions, and examined the responsibilities of food business operators. We also armed you with knowledge of enforcement powers, sampling procedures, and penalties. Remember this logical flow as you prepare for your final revision. See the Act as an integrated system designed to ensure safe food for every Indian citizen. Knowledge is key, but strategic deployment is crucial for competitive exams. Prioritize high-yield areas like the FSS Act, focusing on frequently tested sections. Practice active recall by explaining topics and solving multiple-choice questions, especially scenario-based ones. Revise regularly, stay updated with FSSAI notifications, and manage your time effectively during the exam. A strategic approach coupled with composure is the formula for success. As we conclude, it is essential to look beyond the immediate goal of passing the examination and reflect on the profound career you are about to embark upon. Becoming a food safety officer is not the end of your learning. It is the beginning of a lifelong mission. The field of food science, technology, and regulation is constantly evolving. New processing methods, novel food products, emerging pathogens, and sophisticated methods of adulteration will continuously challenge you. Your success as an FSO will depend on your commitment to continuous learning, staying abreast of scientific advancements, and adapting to new regulatory landscapes. The FSSAI and other bodies offer continuous training and capacity building programs. Embrace these opportunities to sharpen your skills throughout your career. The role of a food safety officer demands more than just technical and legal knowledge. It demands an unwavering commitment to integrity and ethics. You will be placed in a position of significant authority, with the power to impact businesses and livelihoods. This power must be wielded with immense responsibility, fairness, and impartiality. There will be pressures and temptations, but your guiding principle must always be the protection of public health and the uniform application of the law. Your reputation for being honest, fair, and thorough will be your greatest asset. Remember, you are a public servant first and foremost, and your duty is to the millions of consumers who trust you to keep their food safe. This career offers a unique opportunity to make a tangible and visible impact on society every single day. Every clean kitchen you enforce, every unsafe food product you remove from the market, and every business you guide towards better practices contributes directly to preventing illness and promoting well-being in your community. It is a role where you can see the direct results of your hard work in the health and safety of the people you serve. This sense of purpose is a rare and rewarding aspect of the job, one that can provide immense professional satisfaction. You are not just enforcing a law, you are building a healthier nation, one inspection at a time. We wish you the very best in your upcoming examination. Prepare diligently, stay focused, and believe in your ability to succeed. This video class series has provided you with a comprehensive and strategic foundation, but the final steps on this journey are yours to take. Go forth with the confidence that you are well prepared, and with the aspiration to not just become an officer, but to become an exemplary guardian of the nation's food safety. Your journey starts now, and it is a journey of immense importance, responsibility, and honor. Good luck, future food safety officers.